Good morning, everyone. Good morning. Good morning, Instagram. Good morning, YouTube. Good morning, Facebook. How's everyone doing? I'm just going to wait for some people to tune in. Say hi as you enter. Let me know where you are tuning in from. What city are you in? What state are you in? I'm actually in Atlanta right now, and I'm going live from my hotel room in case you're wondering why my background is different. I'm actually happy to have escaped Florida this week with Hurricane Elsa. So hopefully it's not too bad for those of you in Florida right now. So I can see you guys all joining in. I have a good topic today. So before I start, definitely share this video with your friends, your family, anyone that is trying to immigrate or might need immigration assistance. Also, like us on Facebook and hit the subscribe button if you are on YouTube. The more participation we get, the more people that need us help are able to see, and it's able to appear for them. Cecilia says, good morning, beautiful. It was nice talking with you yesterday from Indiana. Yes, Cecilia, good morning. How are you? I hope you're doing good today. Okay. Let me get started. Again, for those of you who don't know me or are tuning in for the first time, my name is 𝐏𝐥𝐞𝐚𝐬𝐞. I'm an immigration attorney. I am primarily based in the Orlando area of Florida. We have a satellite office here in Atlanta, but I take clients in all 50 states in the United States with their family immigration matter. So it doesn't matter where you're located. Immigration is federal law, and I'm happy to assist you with the process. For those of you on Instagram, my phone number is 407-995-6567. And, those of you on Facebook and YouTube, you can probably see my phone number just scrolling through there. So make sure you just save it. Pardon me if you see me going up and down because I have one screen up on Instagram and the other screen on YouTube and Facebook. That's why, if you see my face moving up, it's not that I'm ignoring one screen. And as always, this lives are really supposed to be casual conversations between me and my audience. If you have immigration questions, feel free to ask them in the comment box. I try to get to as many as I can within the time that I have. So feel free to ask the questions. So today, I want to talk about sabotaging and how spouses can do this and what needs to happen if this happens. So what do I mean when I say, is your spouse trying to sabotage you? Sometimes, you might be married to a U.S. citizen or a green card holder, and, maybe they have a control issue, right? Or maybe they've asked of something of you that you didn't give them, whether it's be financial, whether it be intimate or whatever it is. And because of that, they are interested in ruining your life, basically. There are people that are just very vengeful, for lack of a better word, that just want to, destroy their partner in every way they can. So what it is people do, those people end up going to, the person may have filed an immigration petition for you. And you guys attend, the interview, and during the interview, they ask questions, and the person starts saying the opposite, the complete opposite of what the answers are, knowing fully well that what they're saying is not true. Like, oh, what is your spouse's last name? And the person's like, I don't know my spouse's last name. That is obviously an attempt to sabotage, you in your green card application process, because most husband and wives know each other's know how to spell their last names, right? Or that they don't know what country you're from, or they get the country you're from wrong. Or you say, oh, we met here, and the person says, no, we met here. Or you have an interview scheduled, and the person says, I'm not going to show up to the interview. If you don't give me this, I'm not going to come to the interview. So when things like that happen, one of the things that I generally recommend is, consulting with an attorney, because two things can happen. One, if they go into that interview and they just go and say whatever the hell they want to say, you could get a notice of intent to deny based on them believing that your marriage is a sham. Meaning that your marriage is fraudulent, when in reality it's not. But because your spouse is trying to do that to you, they go in there doing it, right? And if you get a marriage sham judgment, that is a really, really, really difficult judgment basically to overcome. So you want to be able to get a hold of things and situations before it gets to that point where you get what we call annoyed, which is a notice of intent to deny, or an actual denial that specifically states your marriage is a sham, your marriage is not real. Again, for those of you guys that just tuning in, please feel free to comment in the box. Let me know where you're tuning in from, what city, what state, and then ask your questions in there. Once I finish talking about this, I am going to definitely answer your questions. And again, please like this video, share this video, subscribe to our YouTube channel, and follow us on Facebook for more updates whenever we go live, or, generally I just try to update you guys, on what's going on in immigration. And for those of you who tune in normally, this is not my normal background. Again, I'm in Atlanta. I'm, going live from my hotel room. So that's why it's so dark in here. Okay. So, what do you do when things like that happen? So it depends. So the first thing you want to do is you want to consult with an attorney, because you want an attorney to be able to intercept, and help you with what's going on. So one of the things that I always want to know is the history of the relationship with those two people when I see a sabotager, because sometimes there is a level of domestic abuse and extreme cruelty and control, or abuse of the legal system going on in there, where the person says, if you don't do this, I'm going to make sure I do everything within my power to make sure you get deported, to make sure ICE comes and gets you, to report you to the IRS, for working under the table. And so a lot of times, if we determine that you qualify for VAWA, which I will explain in a second, we can do what we call a continuance or an abeyance, where we go to immigration and basically state that we want to pull this case out from their spouse, petitioning for them, because they are going to now be filing based on VAWA. And this usually happens after an evaluation, and we determine that you qualify, for VAWA. And when we do this, your information is confidential. So your spouse is not going to know what is happening, because USCIS cannot disclose that to your spouse. Your spouse cannot call and say, oh, well, what's going on with the case? And then USCIS will tell them, because USCIS cannot disclose that to them. There's a hefty fine, if any officer does that, because they take victims and their safety very seriously. So everything is confidential. And then usually what we do is we then submit your VAWA application, and we try to merge it with your marriage-based case, with your marriage-based petition. That way, it helps you, so you don't have to pay any filing fee, and you can continue to work without waiting for a new work permit. If you already have a work permit. If you don't already have a work permit, then we can then put in the application. But if you do, it allows us to merge the two cases and basically say sayonara to your husband or your wife, just so that you can get your freedom. So that is one of the quickest ways to take your power back. You do not have to be in a situation where you're being sabotaged. If you even suspect that they're going to do that before your interview, call an attorney so that an attorney can either attend with you, or call me, I should say, call me. So we can either attend with you or send you with a letter to give immigration, because what you don't want, like I said, is to go there. The person says the opposite of what you say, and two things could happen. One, you get the marriage sham, or they take the other person in the other room and force them to sign a withdrawal of the application, threatening them. Right? That if you don't sign this, we're going to say, you did this, did that. And then they withdraw. And then you have to go back to the drawing board, and pray to God that you don't get a notice to appear in front of an immigration judge for deportation. So it's really important that when you're in that situation, that you don't allow, your spouse to hold you hostage, but that at least you get some counsel from an attorney to find out, well, what are my options? I filed this petition with this person. This person, did not, show up, or this person, or wants to do this to me. Okay. So that is how you basically take control of a sabotager, and stuff like that. So I'm going to take your questions. I see some questions coming in on Facebook. So Sandra says, good morning, Aisha. I live with my husband. He's not helping me to pay the bills at all. I have to work 7 days for the week to pay bills. What can I do? I have a 2-year green card and I'm sick and tired of him. I don't know what to do. He's not helping me do nothing. I want to go. I don't know what to do. I have to stay in this marriage to get the 10-year green card. Please tell me what to do. Well, the first thing is, Sandra, I am so sorry that you're dealing with that. But no, you do not have to stay in a bad marriage. You do not have to stay in a bad marriage to get a 10-year green card. Guys, if I didn't make myself clear, let me make it clear again. You do not have to stay in a horrific marriage that's causing you your peace of mind, that's making you sick, that's giving you suicidal ideations because you believe that is your golden ticket to get a green card. There are options for you. And I understand that a lot of people don't know what their options are. That is why I come on here every day and I talk about it. Listen, you don't even have to hire me, but you need to know what your options are because, with this pandemic, the rise in domestic violence, domestic abuse, suicide, because people are forced to be in the same household with their abusers on a permanent basis is scary. It's scary. So Sandra, in your situation, I would suggest, I will explain a little bit to you guys what some options are if you're in a similar situation. But Sandra, give me a call because I would like to evaluate you to see if you qualify for what I'm about to talk about. And my number is 407-995-6567. Again, it's 407-995-6567. You can also send us a message on WhatsApp if you want us to call you. 404-333-8751. So now, if you're in a situation where you have a green card, a conditional green card, which is basically a 2-year green card, typically you need to remove the conditions in 2 years. And if your spouse is not there normally to remove the conditions with you or sign that form, usually you will basically lose your green card status. Okay, you lose your legal permanent resident status. However, there are exceptions. So let's talk about the exceptions. The exceptions are, one, if you file a divorce. If you file a divorce, first of all, you don't even need to wait till your 2-year green card expires. You can submit a removal of condition by yourself. Let me repeat that again. You can submit it by yourself, requesting a waiver stating, look, I have a good faith marriage. I married this person. I believe my marriage is going to work, but irreconcilable difference, infidelity, whatever the reason why you're filing for a divorce, I'm going to get back to you guys on Instagram. Somebody's cracking me up there. You file your divorce as long as you can show that you entered into that marriage with the intention of making that marriage work. But because of the behavior of your spouse, your marriage cannot work. And so you then filed for divorce. You can remove the conditions and get your 10-year green card. The critical thing is you have to show proof that your marriage was bona fide in the first place. So that's number one. Number two, if you have a spouse, like what I just talked about, sabotager, a spouse that is abusive. If you watched my live yesterday, for those of you on Instagram, I didn't go live on Instagram yesterday. I went live on Facebook and TikTok, but you can go to Facebook or YouTube to watch that live from July. What was yesterday? Was yesterday July 6th? So from July 6th, I specifically talked about signs to know if your spouse is abusive or extremely cruel, in case there's a blurry line or you're not sure. So if your spouse, the example given here has specific symptoms based on what it is that I talked about yesterday, you can file for removal of conditions based on extreme cruelty. You can file for removal of conditions based on abuse. If your spouse is extremely cruel to you, or if they're, or they're abusive towards you, you don't have to stay in the marriage. You don't have to. And again, there is no timeline. You don't have to wait 2 years. You know how normally when you get a conditional green card, you get it for 2 years. You don't have to wait 2 years if after a couple of months, after 6 months of being married, it's unbearable. You don't have to wait. Same thing, even after the 2 years pass, and you forgot to renew it, to remove the conditions, you can still file. Same thing with divorce. Even after the 2 years have passed with your conditional green card and you just never did it, you can still file. And you can still file and reactivate your green card while your case is pending. So please, please, please do not sit down and suffer. Do not sit down and just suffer thinking that you don't have any options. And that's why I was saying knowledge is the first step to freedom. You know, you coming here today, Sandra, might be knowledge for you that will lead you to your freedom. But for anybody else listening, you know, if you have a conditional green card, you don't have to stay with a person because you believe that, you know, they're going to do all the things to you and there's no way out of it. Same thing for those of you who your spouse has never even filed an application for you, but they're U.S. citizens or green card holders. If that spouse, we can show that the spouse is extremely cruel to you and abusive, and you have a legit marriage, you can get your 10-year green card. You will skip the 2-year phase. You will go straight to a 10-year green card, even if you've been divorced, as long as the divorce has been less than 2 years. That's if you're doing a straight up VAWA. So OJ Blazin on Instagram says, you're right about that. Exactly. So let me take some more questions. So let's see. Okay, so Arthur K says, my wife has filed for me. I'm waiting for our interview. She always wants me to pay all the rent without helping me. My finance is not up to the rent for the whole month. What should I do? Again, Arthur, you're one of those cases where I would say definitely call me because I want to evaluate what is going on in your case. You asking me the question here is speculative. I mean, there's certain things that somebody might say or asking a question that raises a red flag, but speaking to you will, I want to be able to give you a confidential consultation, which you do deserve. I will be able to ask you and get into more details about what's going on in your marriage to determine if you actually qualify for VAWA. Because if you do qualify for VAWA, then we can just do the abeyance and skip the interview process so you can file VAWA. So call me, 47995-6567. Okay, so let's see what else. Hi, Sean. Good morning. So Sean says, good morning, Aisha. After receiving prima facie determination, what's next and all along? Okay. So after you receive your prima facie letter, for those who don't know, a prima facie determination letter is what USCIS gives applicants who file for VAWA if they believe that they have met the bare minimum standards. Again, I just did a live, I want to say last week, on the bare minimum, which are one, that you have a good faith marriage, you cohabitated with your spouse, you're a person of good moral character, there's some abuse going on in your marriage. Okay. A prima facie is not a guarantee that you'll be approved. It's also not a guarantee that you might not receive an RFE. Okay, somebody says on Instagram that they have questions on top. Okay, I'll scroll through and see if I can find your questions. So it's not a guarantee of that, but it's a good sign that your case is progressing along nicely. With a prima facie determination letter, what it does is that if you have children that are under the age of 21 years old and are not U.S. citizens, were not born in the United States, even if they live outside of America, even if they live inside of America, even if they live with the other parent, they will be automatically listed as benefactors or derivatives of this application. And what does it mean to list them as a derivative of this application? It means that if Sean had a child and Sean got approved for VAWA, his children would get approved for VAWA, and those children under 21. And that way they can then get your green card. If they're in America, they can file a green card application simultaneously with their father or mother who's filing for VAWA if they're married to a U.S. citizen or if there's a visa available and they're doing it based on green card. And if they're outside of America, once they get the approval, then they will continue the next steps in doing what we call a consular processing. So that is the first step. After you get your prima facie, depending on if you did a traditional work permit application based on your marriage to a U.S. citizen, you will get two things: your biometrics requested to go do your fingerprinting, or a bypass. Right now, since the pandemic, they've been doing some biometric bypass if they have a recent biometrics on record for you. So, you may get a bypass, whatever it is, or they will send you to do your biometrics. And then after that, usually you get a work permit and a travel permit. Work permit and travel permit usually come in one card. Sometimes you will not get a work permit if you are in removal proceedings, or you've been ordered removed. And with the work permits, of course, it allows, usually I want to say average takes between 6 to 8 months. I would say most people get it around the 6-month mark, but it could take between 6 to 8 months. Hopefully it goes back to 4 to 6 months, which is what it used to be before the pandemic. That would be great. But just put in your mind that around that 6-month mark is the earliest you'll get it. However, of course, some people are lucky and get it earlier than that. So that's the next step. You get that and you get your travel authorization, your travel permits or advance parole. It's all the same thing. And then once you get that, the next thing is, if they don't have anything else that they need from you and all they have is enough for them to make a decision, they will make a decision. But remember that with each valid case, it takes 2 years to 2.5 years for a decision. So while your case is pending, you will continue to be able to work, right, with your work permit. When your work permit is about to expire, we can renew your work permit so that at least you continue to have no interruption in your work while you're waiting on your case. Once your valid case is approved, you will be scheduled for an interview. Sometimes they may bypass the interview. And after the interview, you will get your 10-year green card. So that is, the life cycle of what happens after a prima facie. Okay, so let me take some questions on Instagram. If an overstayer files for a divorce from a marriage that didn't work out, do you think appearing in court will cause problems or get them locked up? The answer is that it depends. So when you say you filed for divorce, are you talking of family court? Is that the question you're asking? His one and only on Instagram. So family court is different from immigration. While I can't tell you what family court do because I am not a family law attorney, but generally people file for divorce all the time, whether or not they have papers or not. There's no agreement between USCIS and family court like there is with, you being arrested. That's a different story. You being arrested and being referred to ICE, which was prevalent in the previous administration. So, what I would suggest to you is get a family attorney, and that person will be able to counsel you better. Okay. All right, let's see. If someone would want to file for papers after their wedding, how much do you charge? I'm happy to discuss my pricing and what you qualify for. Give me a call, 407-995-6567. Somebody says, can you travel to Canada with advance parole? Absolutely. You can travel anywhere, other than, let's go back. If you have a pending asylum case and then you filed for a different application and you got advance parole, you cannot travel to the country that you're seeking asylum. Let's get that clear. Other than that, if you have advance parole allows you to make international travel, or local travel and come back. One of the things that I would suggest to people is, at least to my clients, if you're traveling, try not to travel for a long time. Try not to travel for more than 30 days just because, if you travel and you get a biometrics appointment and you need to go for it and you're out of the country, it's hard to come back. It's hard to change your ticket. So make sure that, you don't travel for a long time if you travel. Okay. All right. So let me take some more questions on Instagram. Someone says, how long does it take to get a green card interview now? It says ready for interview in June. How much more months? It really depends on what city you're in, Aldeno, and it also depends on their backlog. Ready for interview just simply means that they have everything from your application that they need to schedule you for an interview. It doesn't mean that they're going to schedule you for an interview. I will say that my cases in Florida area are taking about almost a year to date of when we submitted the application, like a full year. However, whereas I had a case, in Maryland that took 4 months from application to green card. So that's not necessarily the norm, but, just putting your mind or in your head, 12 months is the minimum, for a green card interview. And to further prove why this is the case, that is why USCIS has decided that everybody now that applies freshly for a work permit is going to get a 2-year work permit. And the reason why they're giving that 2-year work permit is because a lot of people are filing for renewals of work permit, and it's creating a backlog because there's already so much backlog with decisions. So they're like, you know what, give everybody a 2-year work permit so that it can hold them off while we're working on their case, and they don't need to add more files for us to review, like your work permit and stuff like that. So keep 12 months in your mind. If it's earlier, wonderful. Okay, so Tiffany Bow says, good morning. I filed for VAWA. They requested more evidence. I've overstayed my time. I'm now divorced and returned home to the Bahamas. I received an appointment to do my biometrics. Will they allow me to go to this appointment? What? Do you mean that you just left without getting advance parole and you have a pending petition? If that's the case, that is not good. That means you abandoned your application. But I'm not sure what that is the case. But for you, I would suggest a consultation, 407-995-6567. Let me understand a little bit about what exactly is going on with you, okay? So Aldana says, where exactly is your office in Atlanta? So we actually have a satellite office in Alpharetta area. But most of our consults we do via Zoom or phone consults, but I love to see people on their faces. So I prefer Zoom so you can see me and I can see you. If you're within the local Florida, Orlando area, you can come to our office, on International Parkway. You can also come there now that, the pandemic is slowly reducing. You just have to follow, COVID protocols. So Glory says, how soon can one apply for a 10-year green card after receiving their 2-year green card? The earliest time would be 90 days before the 2-year expiration. So let's say your stuff expires in December. The earliest time would be, I'm so horrible with my math. Anyway, 90 days before December. That's the earliest you can apply, unless you fall into one of the categories that I mentioned earlier, where you're dealing with divorce or you're dealing with an abusive spouse. If that's the case, you can apply as early as you want or as late as whatever. Okay. Okay. F Man says, what happens when you file for adjustment of status on a marriage-based case without submitting your medical examination? Nothing. Actually, I don't submit medical examinations for a lot of my cases, unless it's a parent or child-based application, because with those, I know that it's easier for them to make a decision. The reason why we don't submit medicals is because we don't want your medical exam to expire by the time the interview is scheduled. So instead, we take the medical exam with us to the interview. So don't panic. If you didn't submit a medical exam, once they schedule you for your interview, go get a civil surgeon, do your medical, and take your unopened envelope with you to the interview. Okay? So Andrea says, same situation like Sandra, just that the interview was done. The case is under review 5 months now, and also have 2 kids on the filing and nothing from them yet. So should we stick it out? No, you should not stick it out. Give me a call, 407-995-6567. Let's understand what's going on and where you are. Are you consular processing or are you in America? All of those make a difference. Okay, so let me see. Let me just take some more cases, some more questions on Instagram. Good morning. Is it possible to get a work visa as a musician, songwriter, and do you work on O visa cases? So I don't handle O visa cases or business immigration cases. So I won't be able to answer your question. I handle family-based immigration. Somebody says, can I file for citizenship while my VAWA is in process or before going for VAWA interview? I already have my 2-year green card. So for those who don't understand, because this question is a little confusing if you're not knowledgeable about the way immigration works. So this person actually doesn't have what you call a traditional VAWA case. What she has, as opposed to a VAWA, is a conditional removal case that is based on extreme cruelty and abuse. So if you have a removal of condition case based on extreme cruelty and abuse, you can file for your citizenship once you count 2 years and 9 months. 2 years and 9. I said 2 years and 9 months. Yeah, 2 years and 9 months from the date on your conditional green card, where it says, residents, permanent residents, or green card holders since X date. So counts 2 years and 90, 2 years and 90 and 9 months from that date. So whatever that date is, you can file. But let me pause here and say this. If you are somebody who is not sure about your application, or sure that your application is going to be approved and that you have a slam dunk case, meaning that you have all the evidence to show that you have a legit marriage, I would suggest you wait for them to make a decision in your case before you do that. But that's up to you. Let's see. So Patrick Dozier says, can you recommend another lawyer to me? No, I can't. But if you want to find another lawyer, you can go to avvo.com and search for asylum lawyers, and I'm sure you'll find one. But I don't know any of their work ethic and stuff like that. So I don't want to recommend someone to you and then they don't do a good job for you. Someone asked on Instagram, can you be outside the USA for 3 months, even if you have a work visa, as in domestic staff accompanying a USA diplomat? So the answer really depends. It really depends. Why are you outside for 3 months? And then somebody says, if I get a 10-year green card without getting a 2-year green card, when can I file for my citizenship? I've been married for over 3 years already. So what you want to do is you want to do the same exact thing. Count 2 years and 9 months from the time you got that 10-year green card. At that time, you can then put in your application with your spouse. If you are divorced from your spouse, then you have to wait until 5 years. So 4 years and 9 months before you can put in the application. Okay. So Glory says, is it advisable to travel internationally with a work permit? Do you mean travel permit? Okay, yeah, I see. You said, sorry, I meant travel permit. Nothing is advisable. I can't give you legal advice because I'm not your attorney. Everything I say here is for literally informational purposes. That being said, do people travel outside the country? Yes, they do travel outside the country. Just don't travel for a long time and come right back. If you're in removal proceedings or potential deportation, do not leave the country. Okay. Someone says, Sophia says, my daughter is 31. How long would it take for her filing to come through? So I guess the answer really depends, Sophia, on whether you're a U.S. citizen or a green card holder. For a U.S. citizen, we're seeing timelines right now in about 6 years. And for green card holders, as long as your 31-year-old daughter is unmarried, we're seeing timelines of about 5 years. So believe it or not, in your situation, if a green card holder, the timeline is shorter by a year. So that's the answer to that. So this person, I can't see the follow-up of your question. Okay, I see. I had my interview 6 months ago, and my case is still under review. What should be my next step? So your next step, if your case is still under review, is trying to do what we call an ombudsman request, just to see if they can push for you, advocate for you to help you get some decision, good or bad, just get you some decision so you can move on with your life. If that doesn't work, you can also try for congressional assistance, to see if that helps. If you'd like us to assist you, you can call us 407-995-6567. Thank you. Okay, someone says, thank you. God bless you. You as well. All right, so someone says, if you're married and your spouse refuses to file your documents and later on abuses you and puts you out of the house, what can you do in this case? You can certainly potentially qualify for VAWA and to self-petition by yourself without the help of your spouse. If that is you, you can definitely call me, 407-995-6567, and I'll be happy to evaluate you to see if you qualify, okay? And then Sophia says she's a green card holder. Okay, yeah. So if as a green card holder filing for your daughter who's 31, as long as that child is unmarried, you can petition for her as a green card holder. Timeline right now is about 5 years. But keep in mind that this changes every month. So every month USCIS issues a visa bulletin where it says basically what's available, when, or how long the case will take, or what date they're processing. So because I say 5 years now doesn't mean tomorrow it might not be 3 years, or it might not be 7 years. So I'm just telling you from July. So in August, we don't know what it's going to be, okay? Okay, guys, are there any other questions before I jump off? Let's see if I missed anybody. And then for those of you who I didn't get to answer your questions, tune in tomorrow at 9 a.m. I'm going to be live tomorrow at 9 a.m. Eastern Standard Time. Those are more of my sporadic lives. I don't really have that much time to spend, but since you guys are telling me that you're loving these lives, I'm going to try and come as often as I can. My normal days, that doesn't change, is Wednesday, every Wednesday at 11 a.m. Eastern Standard Time. I will be live on YouTube, Facebook, and Instagram. Every other day of the week, somewhere around 9, 10, or whatever, I come live on all these platforms, including TikTok. So you can, if your question wasn't answered today, you can also tune in there, okay? Let's see. All right, let me answer 2 more questions and then I'm out. Okay, so Onisha, I am so sorry if I'm pronouncing your name wrong. So you said, hey, love, I got my green card for a year and 4 months, petitioned by my husband. So, okay, your husband filed a petition. Congratulations. When should I apply for my citizenship? So if you're still married to your husband at the 2-year, 9-month mark, basically 3 years, then you can apply for citizenship, provided you've had your green card, for 3 years and you've been married for that long as well. How long does it take to get a green card through marriage? It takes anywhere from 12. So, with immigration, there's no standard. It's difficult to give you a standard time. It could take anywhere from 12 to 15 months. Are there people that it takes longer? Yeah, there are people that it takes longer. Are there people that it takes a shorter time? Yes, there is. But this is the average that we're seeing right now, 12 to 15 months. Okay, people. Yes, someone said put your number on the screen. So let me see if it works. Guys, I'm not used to typing on Instagram while going live. So let me try again. Sorry, people on Facebook, that as I block the camera. Just give me 1 second to type in my number here for, oops, see, I did it wrong. 407-995 6567. So I hope you wrote that down. So I just put it in there. And honestly on Instagram, if you don't get what I just said, once I go off live, you can just go on my okay. Oh, there's a way to pin the comment. This is great. Okay, so it's right there, so you can't miss it. You can also go on my profile. My phone number is also there. Okay. So the question says, somebody says, if you divorce your husband, can you still work with your work authorization? That's a loaded question because it depends on why you have your work permit. Do you have a pending marriage-based case? Divorce, do you have a pending VAWA case? So it all really depends because one voids out the other depending on what, you have. Yeah, so female Maverick, I said, if your case is delayed, you can try an ombudsman request or congressional assistance, okay? Okay, guys. Somebody says, you guys don't want me to leave today. All right, I'm taking one more question, and then I have to work. Please, must your spouse go to your citizenship interview with you if you file a 3-year after getting your green card? Yeah. Yes, they do have to go with you. because you're filing your 3-year based on being married. So absolutely, and you have to show, continued marriage, not just, them showing up with you. You need to show proof that you guys are still married and living as such. Okay, guys. Well, I hope everybody has a great day. You can tune in tomorrow, 9 a.m. Eastern Standard Time, 9 a.m., somewhere between 9 a.m. and 9:05, and I will answer your question if I didn't get to it today. Okay? All right, guys.